introduce to you Teehan, who we are absolutely delighted to have here with us today. Asia, you may remember, was the litigant in the Teehan versus the HSE and Department of Health a few years ago, and I will just leave it to Asia to tell you about her experience of that.
Thanks, Philomena. Thank you to Midwives For Choice for inviting me here today. I have to say I'm dreading it. It's not fun to talk about your personal experience as a pregnant woman in Ireland, unfortunately. Everybody has a right to self-determination. That was my cry during the time I was the complainant in that court case. And I wanted to illustrate for you today how the 8th Amendment denies that right, coming as it does from Elizabeth highlighting for us human autonomy, the ability to make decisions, the ability to be respected. And that 8th Amendment leaves all pregnant women vulnerable without any legal protection or recourse to enforce medical procedures, abuse under the guise of medicine, arrest. It leaves us open to having our children taken away from us by child protective services, or as I like to call it, kidnapping. And it leaves us unable to defend our children because while the child is unborn, it doesn't have parents. So there's no family and there's no parents to protect it. And then the only person who can normally protect it would be the mother, but we're prevented from doing that in Ireland by the 8th Amendment. So I hope to demonstrate for you that it is crucial for midwives to defend, as they have always defended, women as they go through pregnancy and birth. So consent, as Elizabeth has illustrated for us, is about being informed as a woman or a patient by the medical practitioner with whom you are sitting or deliberating your care about the benefits, risks and alternatives of what you are about to undergo, to consent to, or in fact to deny consent to. What's really important is that it protects the medical practitioner. It protects the medical practitioner because it's sensible that you are responsible for your own decisions. They inform you about it, you make the decision, you undertake it. And it enshrines and arises from the principle of self-determination, so that the authority in that relationship rests with the patient. And that's something that's really missing in the Irish maternity care system, where the authority rests within a patriarchal system, regardless of whether it's a man or woman is the medical practitioner. It's a patriarchal system which is controlling the patient, and in this case, the woman. We have a long history of this, unfortunately. The Contagious Diseases Act, one of the first three, brought in 1894, was an attempt to control venereal disease around all the military barracks in Ireland. And what we did is we provided for prostitutes, or people who were suspected of being prostitutes, to be forcibly removed from the streets, given internal exams, and then imprisoned in hospitals if they were found to have any kind of disease. It did not control VD, and it resulted in widespread kidnapping and abuse without recourse in law of women who were suspected of being prostitutes. And much like the 8th Amendment, there was no definition for what a prostitute was. So in fact, it was anybody they fancied picking up from the street at the time. And in a patriarchal system, that's exactly what happens. We have this, what appears to be kind of a benign or almost sensible rule of law. And we imagine that it's going to be implemented by this benign state that's looking after and balancing the rights of its citizens. But in fact, we're sitting in a patriarchal state, and what happens and arises is abuse. And abuse without any way to protect, or abuse without any way to have legal recourse. The national consent policy, which we still have here in this country. The consent of a woman is required for all health and social care interventions. Sound good so far? However, because of the constitutional provisions on the right to life of the unborn, there is a significant legal uncertainty regarding the extent of a pregnant woman's right to refuse treatment in circumstances in which the refusal would put the life of a viable fetus at serious risk. And again, we are left without no definition, as Elizabeth has pointed out, as to what that risk needs to be. In such circumstances, legal advice should be sought as to whether an application of the High Court is necessary. Not negotiate with the woman, not sit down and respect her, talk with her. No, straight off to the High Court. And that's what we do. We coerce and we threaten. Because of this, people can also act with impunity. And what happens when you have people acting with impunity and taking up dominant and submissive roles is exactly what Zimbardo found in his Stanford prison experiment. That's what happens. We end up with abuse and power and bullying and coercion and threat. Ciara Hamilton discovered that when she tried to give birth in Kerry, and a midwife ruptured her waters, not just without consent, but without informing her at all, and the cord prolapsed, and the child was seriously damaged. Mrs. Hamilton actually tried to go to the courts, unlike so many of us who are so frightened and traumatised and don't know what to do. She did. She sought to defend herself and she sought to defend her child, and she went to the courts for restitution, and she was told by the judge that the midwife is the person who is best placed to make the decision at the time. Not only that, Mrs. Hamilton had the awards for the court costs put against her. So for even attempting to defend yourself or your child, you can expect to be punished for the state financially on top of the abuse that you've already received via state-sanctioned medical intervention. Ciara did not have to be informed. She was not able to protect her child, and she was unable to get restitution. Mother A, as Elizabeth has already alluded to, was 13 days overdue, though of course she disputed those dates, but what do women know about when they've actually conceived? The words used, as we hear over and over again, were a failure to cooperate, failure to comply, because failure is something that's like really bad, right? The court was told by the obstetrician in the case, if the woman was to deliver naturally, her uterus could rupture and there would be a grave risk to her and her baby. The baby could die or have severe brain damage, and the mother would be at a serious risk of a hemorrhage. None of this is medically based. None of this evidence-based. All of this scaremongery. And exactly the same obstetrician who was offered to me after I started to take my High Court case. Funnily enough, I decided to decline his care. For me, I made a research-based, evidence-based decision. I looked at 30 years of medical evidence as it's published in the international journals, and I was very fortunate to be in a position to be able to do that. I happened to be an academic. There are so many other women who don't have that type of backup. I also happened to have some of the very best medical care available in Ireland backing me up. And yet, I had no right to self-determination. And I had no ability to take over the parental decision-making for my fetus. That's normally what happens when we have children. As parents, we become responsible for giving that consent or withholding that consent. For me, on a personal level, the fear was very real. I knew what this state was capable of doing to women. I knew that if I stepped into a hospital, I could find myself in the same position as Mother A. For a while there, we thought we were going to win the case, and I was terrified. Because what I had asked for was to be involved, not to be the arbiter, but just to be involved in the decision-making. And that meant that I would have to sit in a room with somebody from the opposition. And if I sat in a room with that person, I had no idea what the legal outcome was going to be for me. Were they going to arrest me? Because that's quite possible, as Elizabeth pointed out. Were they going to come to my home and arrest me? Were they going to take my children into child protective services? Because that has also happened in this country. But you won't hear about it because Solomon's choice is, oh, you're endangering the child? Well, we might just have to call child protective services. And you find me one mother who won't consent to whatever it is that they're asking. That's Solomon's choice. I had to leave the country. I had to leave the country so that I knew that me and my child would have the legal protection of the jurisdiction that I was going to. Still a patriarchy, but I knew I had the legal protection. And because I had to leave the country, I am on the same boat and the same plane as all the other women who have to leave this country because of abortion. But I had to leave it because I was pregnant, because I was trying to give birth in a research-based, an evidence-based environment. That's not right. So, as Midwives for Choice, it's so important that we back up this, that we fight for all we are. None of us are victims unless we actually want to be. Very strong, very powerful humans, women and mothers. Thank you.